Okay, this is volume 2 of the Third Fridays podcast from quarantine. My name is Christian Cisan, and we really do this podcast from the kill room at the office, but getting a little bit more used to our remote capabilities. A recap from last month is more COVID-19 issues, right? The board beefed up their response and their update to how issues are going to be litigated and handled before law judges and the board panel. And we provided a practical way to go about handling them. So as we delve into the whole business as usual theme that we're telling clients, right, it makes more sense to actually revert back to what is happening in our world outside of COVID-19. Now, we can't forget about it completely, so there is a board panel decision we're going to discuss, but my guests today are Jeremy Janis and Adam Lowenstein. Welcome to the show, guys.
Thank you.
Thank you. Appreciate it.
Now, Adam, I guess there are a slew of different things I could say that reference, someone's first time on the show, but we'll keep it a little bit PG. But because it's your first time, why don't we start with you with a case that you litigated before the appellate division. Talk to our listeners exactly what happened in your case.
All right. So basically, this was a claim where we had litigated at the initial level. Ultimately, the board, the law judge, established the claim. We then appealed the establishment of the claim. On our argument for why the claim should not be established, it was a fight between two employees. We felt that it was unrelated to the work activity, and therefore we filed an appeal on that basis. We filed the RB89 along with our appeal. The board panel decision, the board then found that they would not consider the appeal because box 15 on the RB89 did not give the specific date as to when the objection was noted.
So that's a crazy outcome at first, right? And we think about that when most of our clients think of us in court, making these substantive arguments, right, as to why a case should not be established, right? So in your case, and Jeremy, the board comes back and says box 15 isn't checked. So what is box 15 and why does it matter to the board?
So box 15 is a box that in which you're supposed to indicate when an exception was noted. They want it to be very specific as possible, what the exception was noted to, the date of the exception.
Yeah, right. And Adam, we're going into court and we're appealing from a specific hearing and we're writing a brief, right? So in my mind, box 15 is rather useless as a way to, to not hear appeal. So it almost reeks of laziness. I mean, dare I say.
And that's what we basically said in our appeal. The main thing is, and my argument was that box 15, the instructions for it, did not say specify the date. It just said note when the exception was noted. So in our RB89, because there's another box at the top of the form that says specify the decision and the date that you're appealing from. So in box 15, we just said what our exception was and that it was noted at the time of the hearing. So my argument was that sufficiently says when the exception was noted, and that fulfilled the requirement. The board ultimately found that they would not hear the appeal for that reason, and then the board panel decision affirmed that, saying that there was no error of law or fact, which again is ridiculous and just, as you said, sheer laziness of they just don't want to review the appeal.
Think about in Corona world, right? Let's say you have a favorite deli, right? You want to get a sandwich and they are not used to taking, takeout orders from you. And so you call ahead because you want to support a local business, and you say, I would like these 4 sandwiches. I'll be there in 30 minutes. And they're like, great. Give them a credit card number. They scan it. You get charged, so there's no contact, and you make an agreement so that nice bag of 5 sandwiches are out on the doorstep waiting for you to pick up. Then when you go to the deli, you find no bag of sandwiches there. You open the door and ask them, why aren't my sandwiches here? And they say, oh, well, you didn't take a number because that's when you come in and order. And it's like, well, we've been doing that for years. And our office is one of many offices on both sides that haven't been filling out box 15 in the way that the board suddenly wanted it to be filled out, even though the brief had it listed. So what do we tell the client when that happens, Adam? Like, how do we give that bad news to the client and move forward?
I know when I got the decision, I said to them, we're absolutely going to bring this to the next level because this is a ridiculous decision. It's been, I did notify them that the board had all of a sudden started this trend and that it happened quite a few times, but it was definitely something that was worth fighting, and we have to bring this further on and get some sort of good law or good determination on this, because to do something like that is very arbitrary, and there's no standing and no reasoning behind it.
So then the client gets on board, and we go to the appellate division, and what is the appellate division rule? I mean, I guess we wouldn't be doing a podcast if it didn't have a bad result, right? So our clients can rest assured that this is a good outcome for us. But what did the board panel say?
The board panel basically said that the appellate division basically said that the board and the board panel abused their discretion in just saying that box 15 was not properly filled out and we're not going to consider your appeal. They cited our argument basically that the other areas of the form said when the exception was noted and what the argument was, and that there was no specific instruction that the specific date had to be there. So the appellate division clearly agreed with all our points and basically determined that the board was just being lazy.
And you find a way to get a result like this. And the unfortunate thing is that an employer and carrier has to really keep this underlying bad decision at their feet and wait for the third department. What kind of takeaways can you give the client, not just for their case, but for other cases? How can we use this to really work on other files, give advice to our listeners of today? Anything that this decision, while favorable, can we use for cases elsewhere?
I think with this specific decision, since there were so many cases that were getting ruled on the same way, that the board was saying we're not going to consider your appeal, I think we have a good argument now to go back and review some of those cases and see if we now should reopen those files and see if we can get those decisions overturned, citing this particular case now.
Yeah, it's not a bad point, right? I mean, there are cases out there, right, that may even be awaiting a poor decision from the board panel. If those are one of your cases, even if it's not from our office, right? The case is Monet, MONE, versus Deer Park Sand and Gravel Corp. We don't have an appellate division publication citation, but the slip opinion citation is 2020 New York Slip Op 02228. And that's a decision that just came out on April 9th. So it's barely a month old. I think that, the abuse of discretion is very, very commonplace in most administrative areas of law. And it was good to have, some teamwork between our office and a client that can, get on the same page and say, you know, we're going to put our foot down, even though the appellate division process is timely and costly to right a wrong. So good work on that, Adam. It's a good result for the client. We'll move to our second good result, really work done by Jeremy Janis of our office. And that claim, Jeremy, give us the pertinent facts of that case, and you know, what is the background that led to our involvement?
Okay, so this is a case involving a home health care aide who got hurt in 2012. At that time, in 2012, she was working for our client, who was a county agency, but who essentially leased her to Alaya Home Care. At some point in 2012, before the date of the accident, that relationship was terminated. So she was no longer an employee of the leasing agency, but rather directly to the home healthcare agency. At some point, litigation on the issue of employee-employer relationship, who was the proper employer, was started after she hurt herself in 2012. A number of hearings happened through 2015 to 2016, at which time the law judge determined that our client, the leasing agency, was not the proper employer, and the other company was the proper employer. Each one of those, at that time, the other employer was not represented. They never sent a representative to any one of the hearings, but they did receive every notice of decision. And in addition,
they didn't receive anything, right? And you know, we can kind of like read the tea leaves here, where they're going to cry foul and use that, you know, old adage we learn in law school that doesn't really exist, right? Like ignorance of the law is not excuse. Not a perfect analogy there, I'll admit, but they're basically saying, like, you know, all these decisions that I had a copy of should be overturned for these reasons that I could have advanced had I showed up to the hearing, right?
Correct. And they waited actually till 2018 to file an application. Essentially, they file an application to reopen. And they bring some new facts to the table, stating that they relied upon our client, saying we'll take care of it. Just trust us. And they file this application with the board. The board immediately rejects it, stating it's untimely. There's no reason you could have not brought this appeal at the time it happened. So eventually they go to the third department, which is where we stepped in, and we filed a respondent's brief.
And the respondent's brief really goes into the procedural heart, where, you know, how many bites at the apple, right, can a person have when they've had their day in court and they've chosen not to take it. So, you know, from a procedural perspective, again, you know, maybe it's like not something that is readily applicable to each client's case, right? But the appellate division comes down and says, you know, board panel's right. Like, you can't relitigate this years and years after the fact. And you know, the only thing that's kind of interesting is, you know, the new evidence, right? So they say, I'm relying on this. Could you see a situation where you reopen it at the board level, and they say, you know, okay, I want to hear this. Is that possible?
I think I believe there has to be some finality. So initially, first of all, you're supposed to file an affidavit. That affidavit's supposed to say, here's a reason why we were unable to get this evidence at the time it was rendered. I think in a case like this, when it was clear they didn't even show up, there was not even an effort to ever produce that evidence. So I think in a case like this, it's not applicable. But yes, in some circumstances where there's an additional investigation that might allow it.
Right, like, you know, it's a little bit similar to paying without prejudice pursuant to Section 21A, right? You know, if we don't know whether we want to deny a claim, sometimes we pay benefits to a claimant, and we have a year up to that first date of payment, a year after, to deny the claim. And clients ask me all the time, why don't we do this? We can investigate the claim for an entire year. And really, a decision like that has some practical effect to it, right? So in your case, Jeremy, if they want to reopen it, right, they have to give a good reason why, and they have to explain why they couldn't have done this. And in a 21A case, I like to think, well, if you're going to wait the year to investigate it, aren't you going to have to state on the record why you didn't file it and it filed denial initially? Right? What is a judge going to have sympathy over us if we pay for a year and then on day 364 we deny benefits? There is a practical way of doing things. And in your case, Jeremy, which for our clients, the case citation is 2020 New York Slip Op 02696, Zuniga versus Alaya Home Care Inc. Employer-employee relationship is not just a straightforward issue, right? If someone comes to one of you guys and says, who does Lois Law Firm employ? I would like to hope we've all been here for a couple of years. We can rattle off a bunch of names and talk for a while. But if it were that easy, then there wouldn't be a trial, right? Employer-employee relationship almost requires us to prove to the judge how it's impossible for the claimant to be employed by us because he's employed by someone else, right? Going beyond the burden of proof that a claimant has to go through in his or her case. And I think that it's a good demonstration of what we need to do from the outset of a case, right? So another good result, Jeremy, on that Zuniga case that went to the third department. We'll transition now to some current events in our world. I know you guys are on the front lines in hearings every day. We have virtual capability. The board's now requiring that every hearing be virtual, and we're at a point now where adversaries are going to use different cases that may come up against us. And the one case I'm seeing from adversaries is the case of Bowers versus New York City Transit Authority. And in that case, a claimant was found to have a tentative rate with regard to CCP, and the judge finds that permanency is joined. So attachment and permanency are continued for development of the record. Now, just giving you that information, guys, would you think that that is a normal thing to do, or is that just far out of range of what we usually deal with in cases that turn to that point of the life cycle?
I would say that's far out of the normal. I mean, the time that the claimant reaches permanency is the last opportunity for us to raise labor market attachment. Usually a work search is ordered and it's set down for testimony on loss of wage earning capacity as well as attachment.
Right. So the only difference between like a normal case and that case is the fact that we have a tentative rate, right? Because Adam, like what is a tentative rate? Like, does a tentative rate give the claimant an obligation to do anything?
If I'll play devil's advocate here, if I'm claimant's counsel and we have a tentative rate and the treating doctor saying total disability, my argument's going to be claimant's not obligated to look for work because the treating doctor is opining total, and I know claimant's attorneys all the time say, oh, they're entitled to rely upon what their doctor says. So a tentative rate is different than a temporary partial rate in that it's a tentative and possibly can be modified up or down at some point once a degree of disability is determined.
I wouldn't even say you need to play devil's advocate. I would agree with you from a defense perspective, right? If it's tentative, it's what's the meaning of that? It means it's not fixed, right? We can go back and change it. And if you set a tentative rate, that means, at any point, the parties can come back, like you said, modify the award, and what result could come out of it? It could theoretically be a total disability in which the claimant would not have to look for work. So to find a tentative rate means the claimant shouldn't have to look for work. And maybe like it's just one of those things where I agree with claimants' counsels. I mean, you can't find many issues where I do, but ultimately, in this Bowers case, board panel directs it, kind of like what you mentioned, Jeremy, permanency and attachment. It's our last, opportunity to really raise this defense. The claimant, throws a fit, and surprisingly, it goes all the way to the third department. I mean, to go on this issue is really something. And the third department gives a decision that makes sense to me, right? That because the tentative rate was never fixed, then the claimant never had to look for work. But one sentence in dicta, right, says that the claimant is not obligated to look for work until a permanent partial disability arises. And I've seen adversaries start to use this as a reason for attachment never to be raised ever. So I wanted to, talk about it with you guys because, when we go into court and our adversaries, use this gamesmanship, right? Like, how prepared can we be, right? We know that in April 2017, the law changed to say that you cannot raise attachment after a claimant is classified with a permanent partial disability. So if Bowers were to say that attachment is not possible at temporary partial disability, would labor market attachment as a defense exist at all?
No.
Yeah, it'd be very difficult to raise it.
Right? So is there temporary partial disability, permanent partial disability, and then purgatory, right? Like when do we get to raise it? It's just like this weird dichotomy and balance of applying one area or dicta sentence to fit your position. And it's just a reminder to our clients who are listening out there that anytime you hear the word Bowers and attachment, be ready to distinguish it because the claimant's just trying to fool you. So from that, we head to our final case. It's a board panel decision, so not the same persuasiveness as a third department decision, but because we can't get enough of COVID-19, why not just talk about it for a very little bit? It's matter of Republic Services of New York, Inc. And Adam, I think you can kind of touch on this and have some experience with what happened here, because the claimant was directed to produce work search prior to quarantine restrictions. Carrier files an RFA2, gets before the judge and says, you have to suspend benefits. And, some judge who are feeling, rather unfair to carriers or maybe sympathetic to a claimant directs a final opportunity or decides not to suspend benefits. And then the case gets returned during COVID restrictions. And the judge says, well, I'm not going to touch the issue because the board's position is that an employment search is not required. Now, I'm directing this to you, Adam, because you've had a little bit of success with this kind of issue, in court. So explain, what has happened in your cases, just very briefly, with respect to this issue.
Okay, so the ones that I've been able to successfully argue were when a work search was directed prior to the COVID restrictions being put into place. Generally, they were falling December, January hearings where they were directed with a 60-day return date. Some of them did even stretch. One case I'll tell you about stretched a little bit further in terms of the 60-day restriction, fell just after the COVID restriction started. But I made the argument that the work search was directed prior to the COVID restrictions and nothing was submitted as far as a work search prior to the COVID restrictions being started, and that was the deadline. The one judge had stated that, yes, the deadline for the work search did fall after COVID restrictions had started, but it was only a week or so, and the claimant should have had something, shown some effort prior to COVID restrictions. So I know a lot of these judges are just saying, oh, the board told me not to address it, so I'm just gonna, let it hold an attachment and let the carrier file an RFA2 later on. Meanwhile, the carrier is going to be paying this entire time. So I would make the argument every time you can that it was directed prior to the restrictions and some effort should have been shown prior to the restrictions being sent down.
Yeah, that's a great argument, right? Like, imagine if the claimant was not required to look for work during these COVID restrictions, which is, I guess is actually the case. They would essentially have to say that if they had that extra week, then they would have had a bunch of work. And then even if that were the case, we'd be saying that this doesn't fly under American Axle, right? You can't look for work within a week's period and say that you're attached to the labor market. So, good argument on your end. Really demonstrating the board's position here, even though a judge seemed to kind of apply the facts correctly and in line with how we feel attachment should be dealt with. But in this case, Matter over Public Services of New York, Inc., board panel came down very quickly on the carrier saying, okay, fine, we're going to suspend awards for work search not provided during the COVID restrictions. But once COVID-19 starts, right, executive order, quarantine, stay at home, claimant's not required to look for work at all. And, Jeremy, you've done many attachment trials in your career here. How many times have you cross-examined a claimant who produces work search with Indeed, with Monster, with Google, with Craigslist? Like how often does that happen?
Almost every time.
Almost every time. And, I don't know what's changed, right? And, it would almost be easier to put forth an independent work search because I could say, oh, they're not hiring due to COVID. No one's hiring due to COVID. But they can't even do that. And it actually, we were talking about in the last couple of months of how is this going to react? And clearly, a board panel decision after a 2-month appeal is a little bit crazy in our world. And the takeaway that I propose to you guys, what if a client is really hurt by this, right? How long are they going to have to wait for relief at the appellate division level for this to actually affect them? And like you said, Adam, like they're going to have to pay, right? Like, to me, it looks like an administrative overreach that unfortunately has no practical takeaway in our client's favor. If the board's going to use its administrative discretion to say claimant doesn't have to look for work, even though they can use their computer or smartphone at home, then it seems like carriers are just stuck until COVID-19 restrictions are lifted. But is there anything we can do to leverage a settlement at the board panel level by filing an appeal?
I think an appeal could be filed. Just to note, and even my adjusters have said, hey, let's keep filing these RFA2s. Let's let the other side know we're serious. We're going to aggressively litigate this. So if that one carrier decides, hey, I want to bring this to the next level, could leverage a settlement in terms of maybe the other side says, hey, the carrier might have something on this. They might be able to overturn this since you didn't look for work, you didn't do anything. And that might make the claimant a little bit worried that their benefits might be cut off. So they might want to delve into a settlement at that point.
Good. Yeah, I totally agree. I think it's a reasonable effort to just see what happens, right? What's the harm when legal expenses are a drop in the bucket compared to an ongoing CCP. It's important to give practical advice in an impractical world. So I think that's a great time to close, I want to thank you, gentlemen, for appearing today. So for Jeremy Janis and Adam Lowenstein, this is Christian Cison reminding you to defend from day one.